Good, Mallory made it. How are the roads?
I'm ready.
The House will be in order. The first order of business is roll call. The clerk will unlock the machine and the members will record their presence. Have all the members recorded their presence? Representative Malik is here. Representative Morse is here.
I think we're good.
Clerk will lock the machine and record the roll. The roll call shows 66 present, 4 absent and excused, a quorum being present. The House is ready for business. The second order of business is prayer by the chaplain, followed by the Pledge of Allegiance. Today the prayer will be led by Pastor Tom Doherty, and the pledge will be led by House Page Brooklyn Burke. Will the guests in the gallery please rise?
Writer and educator William Perky says this: "You've got to dance like there's nobody watching, love like you'll never be hurt, sing like there's nobody listening, and live like it is heaven on earth." Let's pray. Our Heavenly Father, thank you for another great day to be here. May this day bring wonderful blessings to all our workers in this place. You have given each one of us in life choices to make. We can choose to be happy or choose to be sad. We can choose to press on in tough situations or to give up and throw in the towel. I pray, O Lord, you would help us to choose that which would bring glory to your name and would encourage all those that we deal with. Thank you, O Lord, for the moments of trial in our lives that strengthen us for future opportunities. When we are feeling weak and vulnerable, lift us up, O Lord, to know that we can make it and we can make good things happen, even in sometimes poor situations. What a blessing it is to call upon you this day and to begin another week. Continue to be with our leadership team in this room and give them knowledge that will help them as leaders. And Lord, be with the support staff today also, and may they all always know how much we appreciate them. Go with us as we begin this day. In the name of Jesus Christ, I pray. Amen.
I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. The House will now advance to the third order of business, approval of the journal. The House is at the third order.
February 25th, 2013. Mr. Speaker, will your Committee on Judiciary Rules and Administration report that we have read and approved the House Journal of the 47th Legislative Day and recommend same be adopted as corrected. Moved by Wills, seconded by Burgoyne.
You've all heard the motion. All those in favor say aye. Aye. Those opposed say nay. The ayes have it. The motion carries and the report is adopted. The House will now advance to the fourth order of business, consideration of messages from the Governor and the Senate. The House is at the fourth order.
From the Senate, February 22nd, 2013. Mr. Speaker, I transmit herewith enrolled Senate Bills 1076 and 1077 for the signature of the Speaker. Novak, Secretary of the Senate.
Senate Bills 1076 and 1077 will be signed by the Speaker and returned to the Senate.
From the Senate, February 22nd, 2013. Mr. Speaker, I return herewith enrolled House Bills 115, 40, 81, 84, 83, and 17, which have been signed by the President. Novak, Secretary of the Senate.
House Bills 115, 40, 81, 84, 83, and House Bill 17 will be referred to Judiciary Rules and Administration for delivery to the Governor.
From the Senate, February 22nd, 2013. Mr. Speaker, I transmit here with Senate Concurrent Resolution 114, 115, Senate Bills 1101, 1102, 1103, 1104, and Senate Bills 1034 and 1035, which have passed the Senate. Novak, Secretary of the Senate.
Senate Concurrent Resolution 114, Senate Concurrent Resolution 115, Senate Bills 1101, 1102, 1103, 1104, 1034, and 1035 will be filed for first reading. The House will now advance to the fifth order of business, report of standing committees. The House is at the fifth order. The gentleman from District 6.
Thank you, Mr. Speaker, for a personal privilege.
The gentleman has the floor.
Thank you, Mr. Speaker. In the gallery today, we have a famous personage. Former Representative Liz Chavez, who is here to observe our proceedings today and also a hearing over in the Senate this afternoon. Would you join the good lady from 6 and I in welcoming Liz back to the House?
Welcome back, Representative Chavez. The House is at the fifth order.
February 25th, 2013. Mr. Speaker, we, your Committee on Judiciary Rules and Administration, report that we have printed House Concurrent Resolution 12 and House Bills 10, 11, 12, 13, 14, 15, 16, and 17.
House Concurrent Resolution 12 and House Bill 210 will be filed for second reading. House Bills 211 and 212 will be referred to Health and Welfare Committee. House Bill 213 and 214 will be referred to Judiciary Rules and Administration Committee. House Bill 215 will be referred to the State Affairs Committee. House Bill 216 and 217 will be referred to the Transportation Committee.
February 25th, 2013. Mr. Speaker, we, your Committee on Judiciary Rules and Administration, report that we have enrolled House Bill 12 as amended in the Senate.
House Bill 12 as amended in the Senate will be signed by the Speaker and returned to the Senate for the President's signature.
February 25th, 2013. Mr. Speaker, we, your Committee on Judiciary Rules and Administration, report that we have transmitted enrolled House Concurrent Resolution 2 to the Secretary of State at 11:31 a.m. as of this date, February 22nd, 2013. Will's Chairman. February 22nd, 2013. Mr. Speaker, we, your Committee on Transportation and Defense, report that we have had under consideration House Concurrent Resolution 8 and recommend that it do pass. Palmer, Chairman.
House Concurrent Resolution 8 will be filed for second reading.
February 25th, 2013. Mr. Speaker, we, your Committee on Education, report that we have had under consideration House Bill 205 and recommend that it do pass. DeMordaunt, Chairman.
House Bill 205 will be filed for second reading. Without objection, the House will now advance to the seventh order of business. Motions, memorials, and resolutions. The House is at the seventh order.
In the Senate, Senate Concurrent Resolution Number 114 by Judiciary and Rules Committee, a concurrent resolution stating findings of the legislature and rejecting certain rules of the Idaho State Police relating to rules of the Idaho Peace Officer Standards and Training Council. Senate Concurrent Resolution Number 115 by Judiciary and Rules Committee, a concurrent resolution stating findings of the legislature and rejecting a certain rule of the Idaho State Police relating to rules of the Idaho Peace Officer Standards and Training Council.
Senate Concurrent Resolutions 114 and 115 will be referred to the Judiciary Rules and Administration Committee. The House will now advance to the eighth order of business, introduction, first reading, and reference of bills and joint resolutions. The House is at the eighth order.
In the House of Representatives, House Bill Number 218 by Education Committee, an act relating to school bonds, amending Section 331107 Idaho Code to revise provisions relating to the issuance of school bonds, to establish certain provisions relating to an annual tax levy, to establish provisions relating to the adoption of an amortization plan, to provide that bonds may be issued as serial or term bonds, to establish provisions relating to interest and that each bond shall be numbered, to provide that each issue shall mature and be paid in full, not more than 30 years from the date of the bonds, and to establish that no issue shall be sold at less than its aggregate par value, repealing Section 331108 Idaho Code relating to the printing of bonds, amending Section 331109 and 1111 to revise provisions relating to the public or private sale of bonds, to provide for electronic bids, to remove language relating to electronic bidding, and to remove language relating to the sale of certain bonds at less than par value, repealing Section 331116 relating to refunding bonds, amending Section 331117 and 331121 to revise provisions relating to the refunding of bonds, establish additional provisions relating to the refunding of bonds, and to revise provisions relating to advance refunding of bonds, repealing Section 331122 relating to the application of other statutes, repealing Section 331123 and 1124 relating to the resolution not to be amended or repealed, repealing Section 331125 relating to the application of bond proceeds needs and limitations and amending Section 33-354 to provide correct code references. In the Senate, Senate Bill number 1101 by Finance Committee, an act appropriating additional monies to the Department of Parks and Recreation for fiscal year 2013 and declaring an emergency. Senate Bill number 1102 by Finance Committee, an act relating to the appropriation to the Department of Self-Governing Agencies for regulatory bonds, amending Section 1, Chapter 278, Laws of 2012 to revise the appropriation to the regulatory boards for fiscal year 2013 and declaring an emergency. Senate Bill number 1103 by Finance Committee, an act appropriating additional monies to the State Tax Commission for fiscal year 2013 and declaring an emergency. Senate Bill number 1104 by Finance Committee, an act appropriating additional monies to the Department of Fish and Game for fiscal year 2013 and declaring an emergency. Senate Bill number 1034 by Judiciary and Rules Committee, an act relating to county jails, repealing Section 2625 Idaho Code relating to the governor's authority to order removal of prisoners. Senate Bill number 1035 by Judiciary and Rules Committee, an act relating to county jails, amending Section 2603 Idaho Code to establish additional provisions relating to the authority to designate detention officers to act as peace officers and to make technical corrections.
House Bill 218 will be referred to Judiciary Rules Administration for printing. Senate Bills 1101, 1102, 1103, and 1104 will be filed for second reading. Senate Bills 1034 and 1035 will be referred to Judiciary Rules and Administration. Without objection, the House will now advance to the 10th order of business, second reading of bills and joint resolutions. The House is at the 10th order.
In the House of Representatives, House Bill 203 by Appropriations Committee regarding appropriations, Department of Health and Welfare, indirect support services, and public health services. House Bill 142 by Health and Welfare Committee regarding dentists. House Bill 178 by Health and Welfare Committee regarding immunization boards. House Concurrent Resolution 6 by Health and Welfare Committee regarding prescription monitoring program. House Bill 162 by Education Committee regarding cosmeticians. Senate Bill 1031 by Commerce and Human Resources Committee regarding consumer transactions. House Bill 131 by Resources and Conservation Committee regarding water. House Joint Memorial 1 by Resources and Conservation Committee regarding Frank Church River of No Return Wilderness. House Bill 102 by Judiciary and Rules and Administration Committee regarding Police Forensic Laboratory. House Bill 103 by Judiciary Rules and Administration Committee regarding fees. House Bill 105 by Judiciary Rules and Administration Committee regarding sexual offender registration. And House Bill 125 by Judiciary Rules and Administration Committee regarding guardianship and conservatorship.
House Bill 203, 142, 178, House Concurrent Resolution 6, House Bill 162, Senate Bill 1031, House Bill 131, House Joint Memorial 1, House Bills 102, 103, 105, and House Bill 125 will be filed for third reading. The House will now advance to the 11th order of business, third reading of bills and joint resolutions. The House is at the 11th order. The House will have under consideration Senate Bill 1016. Good lady from District 30.
Thank you, Mr. Speaker. I ask for unanimous consent to dispense with further reading of Senate Bill 1016.
You've all heard the unanimous consent request. Is there an objection? Hearing none, the good lady has the floor.
Thank you, Mr. Speaker. Good members of the House. The Supreme Court is required under Article 5 of the Idaho Constitution to submit defects and omissions in the law to this body. This is one of the bills submitted by the Supreme Court to correct a defect. This bill simply removes subsection 3, which states that a bail agent's license filed with the clerk of the court is deemed proof that the bail agent is properly licensed. This was adopted in 2010 to ensure that a bail agent could file bonds as long as the agent was properly licensed by the Department of Insurance. Now this provision is no longer needed under subsection 3, and it's obsolete because of technology advances. Anyone can check whether an agent is authorized to write insurance, including bail bonds, by checking the agent's name on the Department of Insurance website. It just takes a few seconds. Additionally, subsection 3 can be misleading because a bail agent's license may have been suspended or revoked since it was filed with the clerk, so it may no longer be valid. Repeal of this section has been recommended by the Supreme Court and by the Court's Bail Bonds Guidelines Committee, which brings together judges, lawyers, court personnel, and representatives of the bail industry. This passed unanimously out of judiciary, and we're aware of no opposition, and I ask for your support here. Thank you, Mr. Speaker.
Is there further debate? Hearing none, the debate is closed. The question is, shall Senate Bill 1016 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Representative Gannon, Representative DeMordaunt. Does any member wish to change his vote? Representative Gannon votes aye. The clerk will lock the machine and record the roll. The roll call shows 67 ayes, 0 nay, 3 absent and excused. House Bill 1016 has passed the House. Is there a correction to title? Hearing none, Senate Bill 1016 will be transmitted to the Senate. The House will now have under consideration Senate Bill 1017. Good gentleman from District 15.
Mr. Speaker, I ask unanimous consent to dispense the reading of Senate Bill 1017.
You've all heard the request. Is there an objection? Hearing none, the good gentleman has the floor.
Thank you, Mr. Speaker. This bill is a bill of bills that the Supreme Court has recommended in its annual report to the gentleman on the second floor concerning defects or omissions in the laws as required under Article 5, Section 25 of the Idaho Constitution. The Idaho Constitution, Idaho Code 19-39 through 19-3944 concerns the procedure followed when misdemeanor convictions is appealed. These statutes date back to territorial days long before the Magistrate Division came into being in 1971. They are now obsolete and in conflict with the provisions of the Idaho criminal rules for such appeals. This bill would repeal the outdated statute, removing confusion and better move appeal properly forward. This bill has no impact on general funds.
Thank you. Is there further debate? Hearing none, the debate is closed. The question is, shall Senate Bill 1017 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 67 ayes, 0 nay, 3 absent and excused. Senate Bill 1017 has passed the House. Is there a correction to title? Hearing none, Senate Bill 1017 will be transmitted to the Senate. The House will now have under consideration House Bill 93. Good lady from District 9.
Thank you, Mr. Speaker. I ask for unanimous consent to dispense with further reading of House Bill 93.
You've all heard the request. Is there an objection? Hearing none, the good lady has the floor.
Thank you, Mr. Speaker. Members of the House, this is a bill which will clarify so that those that live in rangeland will have the same advantage as those who live in the forested land to protect their property and the property around them. Last summer, we all were inundated with the smoke from the fires, as you well know. And this is not only a huge cost to homes and property, but it's also a huge cost in the environment and to our wildlife. And so a rancher group from down by Mountain Home last year decided that they would take advantage of a part of our law which allows them to form an association. This is a nonprofit association. They set their own rules, they assess themselves, but it is overseen by the Department of Lands. Now, in our law, it's not clarified for rangeland associations like it is for timberland associations. So that's what this bill will do. And right now, there is no formal protection on about 2.2 million acres of this rangeland. So the Mountain Home District was very successful this year. They were given a lot of training by BLM. They were given radios, a couple of tankers, and they brought their own cats. And they worked on a few fires on initial attack. And ranchers are usually the first ones out there on the rangeland. When you see smoke, you want to get out there and find out where your cows are and what you can do to prevent them from being burned up, of course. So our hope is this will stop having those huge, huge fires, because sometimes it takes the BLM a long time to get there, to get organized. The BLM was very, very pleased with what happened with Mountain Home. And IDL has now had a request from a group down by Jordan Valley, but in Idaho. They're called the Owyhee Group, and another one over in Sailor Creek. And so this winter, BLM has already trained about 200 ranchers so they can participate in these organizations. For those of you that follow the sage grouse issue, this will be a huge help to protect sage grouse because their habitat is in these rangeland areas. And when they lose their habitat and are burned up, that doesn't do any of us any good. So I would ask your support of this bill. Thank you.
Is there further debate? The gentleman from District 24.
Thank you, Mr. Speaker. Would the good lady stand for a question?
Will the lady yield?
The lady yields.
The lady yields.
Good lady from District 9. Would this allow ranchers to initiate the fire suppression before the BLM arrives on the scene? What is the order of response? Is that specified in the association? We've all seen cases where ranchers were told they could not take preventive measures even though they were on the scene and had the necessary equipment. How would that deal with this issue?
Lady from 9.
Thank you, Mr. Speaker. Good gentleman from 24. That's exactly what this will do. The MOU that is present in the Mountain Home one with IDL and BLM says the association will promptly, diligently, and to the best of their ability control and extinguish the fire using the best methods determined by the association. So they are the first responders.
Thank you, good lady. Thank you, Mr. Speaker.
Is there further debate? Good lady from District 18.
Thank you, Mr. Speaker. Would the lady yield for a question?
Will the lady from District 9 yield to a question?
The lady yields.
Lady yields.
Thank you, Mr. Speaker. Good lady, I'm really concerned about the ranchers' safety, and I know you have liability insurance in this, and you talk about liability, but I'm just concerned that we might put them in harm's way. And can you give me some more comfort with that?
Lady from 9.
Thank you, Mr. Speaker. Good lady from 18. As I mentioned, the BLM has been training ranchers for this to keep them out of harm's way, and they have special protective equipment just like the wildland firefighters from BLM, and they have their radios, and they're very well aware of what the dangers are.
Thank you.
Is there further debate? The gentleman from District 23.
Thank you, Mr. Speaker. Debate in favor of the bill.
Gentleman has the floor.
Thank you, Mr. Speaker. Folks, I happen to know a lot of those ranchers that are out there east of Mountain Home where that fire started up last year. John McCallum and his wife, Teresa. I happened to visit out there during the last stages of that fire, and those folks were first on the line. He had his caterpillars going, he had water machines going with tanks spraying the water, and they stopped a lot of damage that would have happened otherwise. They were the first responders. They love the ground. They want to protect themselves and the consequence of a fire. So I'm in full favor of this bill, and it should be expanded even further and further and further so that we have full cooperation between the men and women who love the ground and make their living off of it and the government agencies. Thank you.
Is there further debate? Hearing none, the debate is closed. The question is, shall House Bill 93 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Does any member wish to change his vote? The clerk will lock the machine, record the roll. The roll call shows 67 aye, 0 nay, 3 absent and excused. House Bill 93 has passed the House. Is there correction to title? Hearing none, House Bill 93 will be transmitted to the Senate. The House will now have under consideration House Bill 128. The gentleman from District 26.
Mr. Speaker, I ask unanimous consent to dispense with the reading of House Bill 128.
You've all heard the unanimous consent request. Is there an objection? Hearing none, the good gentleman has the floor.
Thank you, Mr. Speaker. This legislation will change the life of a lien from 2 years to 3 years, making the time period for canal company liens consistent with the timeline for irrigation district liens. By allowing 3 years instead of 2 years, canal companies will have a better opportunity to work with landowners to address delinquent assessments. Without this legislation, more foreclosures on canal company liens are likely, especially in urban areas. This legislation only applies to Carry Act canal companies and will not impact other canal or ditch companies. This legislation will correct an inconsistency in the current law and is supported by the Idaho Water Users Association and the Food Producers of Idaho.
Is there further debate? Hearing none, the debate is closed. The question is, shall House Bill 128 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 67 aye, 0 nay, 3 absent and excused. House Bill 128 has passed the House. Is there a correction to title? Hearing none, House Bill 128 will be transmitted to the Senate. The House will now have under consideration House Bill 129. The gentleman from District 19.
Mr. Speaker, I request unanimous consent that we dispense with the reading of House Bill 129.
You've all heard the unanimous consent request. Is there an objection? Hearing none, the gentleman has the floor.
Thank you, Mr. Speaker. Members of the body, this legislation changes the rate of interest to be paid for delinquent assessments at the time of redemption from 8% per annum to 1% per month, or basically 12%. This is a housekeeping change that brings the different canal companies and districts into alignment. And the housekeeping change is specific to Title 43, Section 708, and what we're addressing is Title 43, Section 713. This legislation corrects an inconsistency between two different irrigation district statutes regarding the interest rate to be paid on delinquent assessments. The interest rate in the legislation is consistent with the interest rate allowed to be charged by Carry Canal companies for delinquent assessments and by counties for delinquent property taxes. Now, members of the body, I didn't know what a Carry Canal Act was before this, so I thought I would just really quickly describe that. The Carry Canal Act made it so that private companies could develop desert land in the West in the late 1800s. It wasn't very successful except for in Idaho. 60% of all Carry Act canals are in Idaho, so that's pretty great. What this addresses is irrigation districts. Carry canals can currently charge 12%. Irrigation districts charge 8%. What they're trying to do is bring these together into one kind of uniform interest rate for people who are delinquent in their assessments. So with that, I ask for your green light on this bill, House Bill 129.
Is there further debate? The gentleman from District 23.
Would the gentleman from District
19
yield to a question?
Will the gentleman yield?
Gentleman yields.
Gentleman yields.
Thank you, Mr. Speaker. Gentleman from 19. Was there any consideration at all from moving the other irrigation districts that had 12% per annum down to the 8% per annum.
Gentleman from 19.
Mr. Speaker, thank you. The consideration here would then have to include property taxes. And so it's a much simpler solution to move one group from 8% to 12% than it is to change county delinquent taxes from 12% to 8% across the entire state and reduce carrier irrigation district taxes all the way down to 8%. So what this is doing is it's taking a small community that has had tax code that legislative statutes that haven't really been modified since the early 80s and bringing them to current standards regarding the rest of the property-based delinquent assessments.
Mr. Speaker, to debate the bill.
The gentleman has the floor.
Thank you. Ladies and gentlemen, some of us in here, and I didn't know till recently what redemption is. Redemption allows the property owner or the lien holder to redeem the property within 1 year after the property's gone through the sheriff's sale. Now, all we're going to do with this legislation is make it more difficult if a person has had financial troubles for some time to be able to redeem that property if he comes up with the money to redeem it by changing it from 8% to 1% per month. And I don't know if that 1% per month is add-on. In other words, every month the interest is added on, you charge 1% of that. That's compounding interest. I'm not sure just how that works, but if that's the case, it makes it even worse. And therefore, I feel in the interest of the previous property owner being able to redeem the ground that we shouldn't make it more difficult. If anything, we should make it less difficult. Thank you.
Is there further debate? Hearing none, would a good gentleman from District 19 care to close debate?
Just to clarify, the 1%, as the good gentleman from 23 said, there's a 2% penalty for being delinquent on your charge, and this is the interest rate as they're moving toward redemption. It brings all property delinquency assessments into alignment, which is fair and reasonable, and I hope to have your green light on this.
Thank you. The debate is closed. The question is, shall House Bill 129 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 41 aye, 26 nay, 3 absent and excused. House Bill 129 has passed the House. Is there a correction to title? Hearing none, House Bill 129 will be transmitted to the Senate. The House will now have under consideration House Bill 130. The gentleman from District 34.
Thank you, Mr. Speaker. I would request unanimous consent to dispense with the reading of House Bill 130.
You've all heard the unanimous consent request. Is there an objection? Hearing none, the good gentleman from District 34 is recognized to open debate.
Mr. Speaker and members of the House, House Bill 130 is kind of a bill that clears things up on the election of a director to a water district. This bill outlines the requirements for requirements for the qualifications of a director, of a person to become a director. And those qualifications are that to become a director of a water district, a person must own property within the district and reside within the district. There has been occasion in the past where someone may have been qualified to serve on the board of directors of a water district. Then they sold a parcel of their land or their home or something and moved into town or something, and they didn't live there anymore and they were not qualified. And yet they didn't say anything about it. This bill requires notification to the water district if a person who is a director is no longer qualified. But it also requires that a person sign an affidavit that they are qualified prior to the time that they are elected. They have to file that when they file their nominating petition. It also requires that that nominating petition have 6 signatures on it of people who are petitioning to have that person nominated for election to a director. This is a good bill. Most districts have been following this for years and years, but this puts it in statute so that nobody can wonder whether or not a person is actually qualified to serve as a director of a district. This is another thing it does here in this bill that I think is a good thing. Many times there's only one person running for office for a director in a district, and yet present law requires that the other commissioners of the district, the other directors of the district, meet on the first Monday after the election to canvass the votes and announce the election. Well, if there's only one person running and that person got all the votes, there really isn't much need to do that. So this allows the board of directors of that district to canvass the votes and announce the results at their next regularly scheduled board meeting, saving the expense of having an additional meeting to declare one person the elected director. So it saves some money, and most districts have been doing this anyway, but this makes it a statute. So with that, Mr. Speaker, this is a good legislation. This clears up things and makes it clear to people participating in a water district what the rules are and the qualifications are. Thank you.
Thank you. Is there further debate? Good gentleman from District 6.
Thank you, Mr. Speaker. Brief question, if I might.
Will the gentleman yield to a question?
Gentleman yields.
Gentleman yields.
Thank you, Mr. Speaker, and good gentlemen. If a board member ceases to meet the requirements, in other words, they do move into town, are they required to resign from the board under this law?
Gentleman from 34.
Mr. Speaker, a good gentleman from
6.
Yes. A person must be qualified to serve as a director.
Thank you.
Is there further debate? Hearing none, the debate is closed. The question is, shall House Bill 130 pass the House? The clerk will unlock the machine and the members shall cast their votes. Has every member voted? Representative Gestrin. Representative Gestrin votes aye. Does any member wish to change his vote? Clerk will lock the machine and record the roll. The roll call shows 67 ayes, 0 nay, 3 absent and excused. House Bill 130 has passed the House. Is there correction to title? Hearing none, House Bill 130 will be transmitted to the Senate. The House will now have under consideration House Bill 132. Good gentleman from District 8.
Mr. Speaker, I request unanimous consent that full reading of House Bill 132 be dispensed with.
You've all heard the request. Is there an objection? Hearing none, the good gentleman from District 8 is recognized to open debate.
Thank you, Mr. Speaker. Today I bring to you House Bill 132, which is a fire trespass liability piece of legislation. This piece of legislation is to help reduce the exposure that the landowners and contractors have in regards to trespass of fire. Recently, the federal government brought a lawsuit in California against Forest Products Company for the spread of a forest fire. And let me give you an example of what happened in that case. And we must keep in mind that federal common law looks to state law unless it is hostile to the feds, which in this case we're making this uniform for trespass onto any lands. But in that California case, a timber company received a bill from the federal government for $781 million, when actually the suppression costs were $20 million and the net worth of the timber loss was about $22.5 million. So they actually sued for 18 times the actual value. Well, another thing that they added and found in this situation was that they could sue for intangible environmental damage. And that was $470 million in that suit. Well, we found here in Idaho that our statute wasn't very clear when it came to protecting the landowner or the contractor from the trespass of fire when it came to intangible environmental damage. So there's been other cases in the Ninth Circuit that have been not favorable to railroads, county, highway, water districts, utilities, contractors. And so we bring you this bill today, 132, to limit the intangible to actual loss and not intangible environmental damage. Essentially, this relates to, in Section 2, tangible and actual loss and not the intangible environmental damage. And then in trying to further define this, you'll find, actually go back to Section 1 in the legislative intent. It is to make it so its recovery is limited to resource suppression costs, economic damages, and either the diminution of fair market value of the real and personal loss or the actual intangible cost for restoration. And I offer today that restoration costs are based on an industry standard of what restoration cost is, and that's to put native species back out there on the land, not necessarily bring back 100-year-old trees and try to plant them back in the forest. And we go to Section 2. We also put in here that it has to be willful. If there's any time that a fire is started that willfully or intentionally, that would be the only time you would be able to claim treble damages. But it would have to be concluded that it was willful and intentional when the fire was started. Now, if you go to Section 3, you'll find that in negligent or unintentional acts, when it's not intentional, there it spells out exactly what you can claim as a neighboring landowner or as a state or as a federal government would be cost for controlling a fire, and specific economic damages is laid out there. This piece of legislation also contains an emergency clause because we have another fire season approaching, and many times those begin before the 1st of July. There are currently 15 co-sponsors, and there's a long list of supporters for this piece of legislation. Industry, Cattle Association, wool growers, amongst some. Also the Loggers Association, IACI, and others have reviewed this legislation and approve of it. It was passed unanimously out of Resource Committee with a do-pass recommendation. And ladies and gentlemen of the body, I ask today for your yes vote.
Is there further debate? The good gentleman from District 16.
Thank you, Mr. Speaker. I will be voting no on this bill today. We get back to, in this bill again, to the fundamental issue of accountability and responsibility. The common law of Idaho has developed over time in our courts with respect to what the proper measure of damages is. And I want to remind you of some scenarios where this bill, I think, takes on a posture that will be positively harmful to Idaho businesses. One of the things that as I understand it, this bill will not allow someone to recover for is a loss of time. Let us posit a hypothetical. You have a situation where a fire consumes timber in a timber sale, and whoever was going to log that timber and whatever mill was going to process that timber no longer has access to that timber. And what are they entitled to? Well, the owner of the land is entitled to the value of the timber, but the contractors, what do they get? Nothing. If the people who plan to harvest the timber and process the timber in a lumber mill, if those are the people who own the timber, they get the value of the timber. Imagine the cash flow problems if a year or two's worth of timber goes up in smoke, literally, and all you get is the value of the timber. You get nothing for the fact that you're out of business for 2 years. Now, the Idaho courts, I think properly, say in that kind of a situation, you are entitled to additional damages above and beyond the actual value of the timber for the loss that your business suffers as a result of that fire. This bill would give you nothing. Posit another scenario. A corporate jet of an insured out-of-state corporation is negligently piloted and crashes on forest land in Idaho. Timber is burned. Same situation. This doesn't just protect our local businesses. This would protect an absentee from escaping paying the true value of the loss to this state and to companies in this state for a negligent act. Is that what we really want to do here? What about individuals? This doesn't just protect Idaho companies from liability. It would protect individuals who negligently start fires and put people out of work and deprive businesses of business income. I understand the sentiments for this bill. I understand what it's trying to get at, but I think it does it far too broadly, and the implications of what it will do and who will be harmed at the end of the day have not been adequately thought through. Thank you.
Is there further debate? Gentleman from District 15.
Thank you, Mr. Speaker. I have a little different concern than the good gentleman from 16. And my concern is that it seems to me that we're expanding liability where perhaps there is none. If you look at subsection 3 on page 2, lines 17 and 18, that is the current law about what is authorized as damages, and it says that it is the costs in controlling or extinguishing the same, and it outlines that this applies to the state. When we go down to the additional language that's being added, we're adding a lot of different things, including economic damages, environmental impact, and all sorts of things. It seems to me a much better way to approach this, if indeed the intent is to limit liability, is to say that, just put an only in there, and say that it's on line 17, that it's liable only for the costs incurred by the state or its authorized agencies. And if you want to throw the federal government in there for good measure, because that's apparently where this is coming from, I think that would solve the problem instead of adding all of these other counts of damage. It also, I think, would address the good gentleman from 16's problems, that if there are private persons that are damaged that have a claim, they would not be precluded, because this applies simply to state and governmental agencies that are trying to seek recovery of suppression costs. So I think this is and I understand the Farm Bureau and a lot of folks have looked at this, but I have some real concerns about this maybe adding liability where we don't have any, and that it could be handled a lot more simply.
Is there further debate? Gentleman from District 9.
Thank you, Mr. Speaker. And I think we're seeing ghosts in this bill that perhaps are not there. And this is a bill to limit the liability, as the good gentleman from 8 described, that there was a lawsuit in California, and they were sued and got intangible damages. And I think that's what this bill is trying to limit, is those intangible damages from ever being collected. Certainly, you know, and it's a fairness issue as well. If a fire is started by negligence on federal land by the federal Forest Service, you know, if their slash burning or something gets away from them, you have no recourse if it gets onto your personal property, and you can't sue for anything. So I think that this is a good piece of legislation. I think it was fully vetted in our committee, and I think we should all vote green on this.
So further debate? Hearing none, would the good gentleman from District 8 care to close the debate?
The gentleman would. I just, to get to something that the good gentleman from 16 had to say, we do have a provision in this bill for economic damages. So this is where you get your ability for businesses to have the opportunity, because they're the ones that would be economically damaged here. The good gentleman from 9 referred to many times when a fire on the public domain gets away and gets on your ground, you don't have the opportunity to reclaim damages. I can attest to that personally. And this fire would not have been a problem, but a fine firefighter from back east was the one responsible to light a backfire. It burned out a ranch, it burned out, and this is in the Frank Church Wilderness. Burned 3 cabins on a subdivision that I'm party to. And the damage sometimes are tremendous, but on the other hand, you don't have an opportunity. You can file a claim, you don't get anywhere. But we do not need to afford them that same opportunity to burn us out. I think this is a good bill. It doesn't restrict things tight enough, maybe. But today, this is a good start, especially to eliminate the ability to sue for intangible environmental damage. So, good members of the body, I ask for your yes vote today to protect the good people of Idaho. Thank you, Mr. Speaker.
Thank you. The debate is closed. The question is, shall House Bill 132 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 60 ayes, 7 nay, 3 absent and excused. House Bill 132 has passed the House. Is there a correction to title? Hearing none, House Bill 132 will be transmitted to the Senate. The House will now have under consideration House Bill 139. Good gentleman from District 19.
Thank you, Mr. Speaker. I ask unanimous consent that we dispense with further reading of House Bill 139.
You've all heard the request. Is there an objection? Hearing none, the good gentleman from District 19 is recognized. Open debate.
Thank you, Mr. Speaker. Members of the body. House Bill 139 is actually the legislature fixing a perceived overstep by the Tax Commission in 2012. In 2012, House Concurrent Resolution 33 rejected a rule that the Tax Commission had propagated, and the Tax Commission, along with Brent Hill and the Association, or the Idaho Society of Certified Public Accountants, worked together to solve this problem. So in the initial rulemaking process, the initial problem was in audits, our tax commission encountered several abusive partnerships. Those abusive partnerships operated extensively in Idaho, but they had their partners perform services in non-tax states like Wyoming, Nevada, and Washington. And then they would pay their partners through something called a guarantee of payment, thus avoiding paying any tax in Idaho. The problem with that was that if you are an S corporation as opposed to an LLC partnership, you would have paid some tax in Idaho. So there was unfair treatment between what was an LLC partnership and an S-corp. The bill basically involves individuals who own a business and profit from that business and also serve as an officer within that business. Like I said, if the business operates as a C-corp or an S-corp, the salary is to the business owner is taxed to the state where the employee performs the service. So for example, if I perform an outdoor program as a part of my company in Wyoming, I would pay some tax in Idaho because I live in Idaho, and some tax in Wyoming, except for Wyoming doesn't have an income tax. So therein lies a problem, because we are kind of hemmed in by 3 states that don't have an income tax. So the issue became whether or not a guarantee of payment should be considered a distributive share in all cases, or should it be considered a salary in some cases and a distributive share in other cases. What the Tax Commission did is they said it was a distributed share in all conditions when they audited these companies, which meant they had to pay tax in Idaho regardless of where this service was performed. That's kind of at issue here. So this is a somewhat complex bill that actually impacts generally a few people, but these people were abusing the system. So they came up with a compromise. The first $250,000 is paid as a salary. A guarantee of payment is treated as a salary and thus taxed in the states where the services are performed. Anything above and beyond that is taxed as a distributive share and thereby taxed in Idaho because the business is located in Idaho. I'm very concerned I'm going to have questions on this one, so I'm making sure I'm clarifying everything here. And I can't see anybody to the right of me because of this pillar.
You're doing a great job, all except for the reference to a person's name. And so the body would tune up on that little issue. Starting on page 90 in your Mason's manual, it talks about the debate decorum. So anyway, other than that, you're doing a great job.
I meant the good President
Is the gentleman ending his opening?
I am just about done with my opening, sir. I ask for unanimous vote, 100%.
The gentleman can always ask. Is there further debate? Wow. Hearing none, the debate is closed. The question is, shall House Bill 139 pass the House? The clerk will unlock the machine and the members will cast their votes. Has every member voted? Does any member wish to change his vote? Burgoyne? Does any member wish to change his vote? The clerk will lock the machine and record the roll. The roll call shows 65 aye, 2 nay, 3 absent and excused. House Bill 139 has passed the House. Is there a correction to title? Hearing none, House Bill 139 will be transmitted to the Senate. The gentleman from District 14.
Mr. Speaker, I ask unanimous consent that the remaining bills on the third reading calendar hold their place one legislative day.
You've all heard unanimous consent request. Is there an objection? Hearing none, the remaining bills on the third reading calendar will hold their place one legislative day. Good lady from District 5.
Mr. Speaker, I rise for a point of personal preference.
Lady has the floor.
I would just like to ask the body to please join me in welcoming my daughter Amy, who is joining us today in the gallery.
Without objection, the House will... Oh, good lady from District 29.
Oh, yeah. Okay, a point of personal privilege, please.
The good lady has the floor.
Thank you. I have 2 of my granddaughters up in the stand. One is Brooke Jensen, lives here in Meridian. The other is Shantae Jensen, and she's a teacher from Las Vegas.
Welcome to the gallery. Without objection, the House will now advance to the 15th order of business, announcements. Are there announcements? The clerk may read.
Following are the Standing Committee meeting announcements for this afternoon. Business Committee will meet this afternoon at 1:30, East Wing, Room 41, Henderson, Chairman. Commerce and Human Resources Committee will not meet this afternoon, Hartgen, Chairman. Judiciary Rules and Administration Committee will meet this afternoon at 1:30, East Wing, Room 42, Wills, Chairman. Judiciary Rules and Administration Subcommittee will meet upon adjournment, East Wing, Room 42, Luker, Chairman. Resources and Conservation Committee will meet this afternoon at 1:30, East Wing, Room 40, Denny, Chairman. For tomorrow morning, Education Committee will meet tomorrow morning, Thursday, February 26th at 9 a.m., East Wing, Room 41, De Mordaunt, Chairman. Health and Welfare Committee will not meet tomorrow morning, Wood, Chairman. Revenue and Taxation Committee will meet tomorrow morning at 9 a.m., East Wing, Room 42, Collins, Chairman. And State Affairs Committee will meet tomorrow morning at 9 a.m., East Wing, Room 40, Lurcher, Chairman.
The House will now advance to the 16th order of business, adjournment. The House is at the 16th order. The gentleman from District 14.
Mr. Speaker, I move that the House do now adjourn until the hour of 11 a.m., Tuesday, February 26, 2013.
Mr. Speaker, I second the motion.
You've all heard the motion. All those in favor say aye. Those opposed say nay. The ayes have it. The motion carries, and the House will stand adjourned until the hour of 11 a.m., Tuesday, February 26, 2013.
Welcome to Idaho.